Good morning to everybody. Can you hear me in Pecos Hall?
Yes, we hear you.
Awesome. Thank you. Appreciate it. Today is May the 15th, 2025. It's 9 a.m. Do we have a court reporter with us for transcription?
Yes, I'm present.
Awesome. Thank you. Appreciate your efforts today. As I mentioned, this is the May 15th agenda. I apologize. I'm going to be remote as well, and so is Commissioner Bloom. Commissioner Ampoma is in Pecos Hall. Thank you, Commissioner Ampoma. We appreciate it. And Mr. Chandler is also with us. So please bear with me as I'm working remotely for this. We do need to do roll call. So as I mentioned, I am Gerasimos Rosados. I am the acting director for the Oil Conservation Division. I'm also the acting chair for the Oil Conservation Commission. And I will actually, let's keep it on Teams. First, I will transfer it over to Commissioner Bloom.
All right. Thank you, Mr. Chair. Can you hear me okay?
Yes, we can.
Oh, great. Thank you. Hey, good morning, everyone. I'm Greg Bloom, and I am the designee of the Commissioner of Public Lands. Thank you.
Thank you. And Commissioner Ampoma?
I'm Dr. William Ampoma, Professor at New Mexico Tech, and also designee of the Energy Secretary.
Excellent. Thank you, Doctor. Appreciate it. So we are all present for this meeting. So our next agenda item is the approval of the May 15th, 2025 agenda. If we could get a motion to approve, or before we that, any questions, commissioners, on the May 15th agenda?
No questions, that I would move to adopt it.
Okay.
And I second.
Excellent. Great. So our May 15th agenda has been approved. We also now need to do the approval of our meeting minutes. First, for the meeting minutes for April 7th through the 11th of 2025, and then the meeting minutes for April 21st through 25th of 2025. Commissioners, any questions on the meeting minutes?
Mr. Chair, I think you spent the bulk of both those weeks on the Empire midstream case.
Yes.
So I think I would let you and Dr. Ampoma make the motion and vote on that, and I'll sit that out.
Okay, thank you. Commissioner, Dr. Ampoma, did you have any questions on the meeting minutes themselves?
No, I did not. It all looks good, so I will move for the adoption of the minutes.
Okay, and then I will second those, the adoption of the minutes. So the April 7th through 11th and April 21st to 25th meeting minutes have been accepted and approved. So Sheila, if you can jot that down for us, please. Okay, next we go into our pending cases. Our first case today is case number 25297. It's the application of XTO Permian Operating LLC for exceptions to the well casing program requirement under order number R-111-Q in Eddy County, New Mexico. This is a status conference. Are all parties present for this?
Good morning, Mr. Chair, Commissioners. Adam Rankin appearing on behalf of the applicant, XTO Permian Operating LLC with the Santa Fe Office of Holland Hart. Good morning.
Thank you, Mr. Rankin. Good morning. Appreciate it. And Mr. Tremaine, are you also appearing?
Good morning, Mr. Chair, Commissioners. This is Jesse Tremaine for the Oil Conservation Division. We have not yet entered appearance in this case. I believe I do intend to do so, and we will at least comment or observe. I'm determining whether we're going to present any form of case.
Okay, excellent. Is there anybody else that is in this particular case, maybe that's on the platform today? Someone unmuted themselves.
Sorry,
oh, there
sorry
we go.
one moment. Just here, Will Dacus. I'm the Wells Manager for XTO Energy.
And then Tanner Olson, I'm the Wells Engineering Supervisor for XTO Energy for Delaware Basin.
Excellent. Thank you, gentlemen. Appreciate it. Anybody else? Okay, no one else. So, Mr. Rankin, this is a status conference, so let's see where we're at.
Thank you, Mr. Chair, Commissioners. At this point, we're just asking for this case to be set before the Commission on the merits so we can present the bases for the requested exemptions. And so at the earliest convenience to the commission, we would ask that this case be set for hearing, and so the matter can be heard, and hopefully the case can be taken under advisement and approved as requested.
Okay, excellent. I guess, Sheila, when is our next available opening that we have? How does the June docket look?
We have one evidentiary hearing on June 24th.
Okay, so it is an evidentiary hearing, correct?
Yes.
And did they indicate by any chance how long they thought it was going to take?
They have not. We don't have their pre-hearing statements yet. It's a de novo appeal.
And what does July look like?
July is pretty open.
Okay. So just because, Mr. Rankin, sometimes these things take a little longer, maybe we could put you on the July docket?
May I ask Miss Apodaca what the de novo case is for June 24th?
To look it up, I know that it is the American Energy Resources who filed the de novo.
Mr. Tremaine, do you know what that case is?
That's the case with the multiple motions to strike counsel and the title argument between Mr. Samaniago and the company whose name I cannot recall. So at the division hearing below, I believe those legal arguments wrapped in about 30 minutes. That being said, Mr. Samaniago isn't here. I don't want to make any representations as to his case.
Correct. Mr. Rankin, I understand for the sake of expediency, we'd like to do things as fast as we possibly can. That particular case may be a little more difficult, so it may still behoove you to just take the July docket. I think it may be faster.
Understood. I appreciate not wanting to overload the commission's docket. I will just say for the benefit of the client that they have these wells sitting, and they've been sitting for some time and able to produce. And so we would like to be able to move forward as quickly as possible. And if that means presenting the matter in July, then that's what we'll do.
Just due to the contentious nature for the case in June, I think it may actually be expedited if you just waited until July. I really do believe that. I know it's an extra month, and I apologize. I don't mean to be that way. It's just the way that case could be. I think July would be your better bet, and then at least since the docket is open, you would have more of, yours would take priority.
Mr. Chair, if something changes between now and June 24th, when or in advance of the final agenda for June 24th, if it's possible to get this matter heard on that docket rather than the July docket, if something with a de novo case goes away or resolves itself, or it turns out it's going to be a shorter argument, we would really appreciate it if at all possible that we could be slotted onto the June 24th docket, if that would work.
I think that's reasonable. So just keep in touch with Sheila on that one, and Sheila, just let's keep a memorandum in case something does happen with that case. Then we can reach out to Mr. Rankin for this particular case and move it up a month. Would you be able to do it that quickly, Mr. Rankin, if we found out to be able to move it up a month like that?
I'm looking at the gentleman on the screen, and I believe the answer is yes.
They're nodding. I see their heads nodding yes. So okay,
that's right.
Okay, great. Thank you, gentlemen. So let's do it like that. If we get any changes with that particular case that's set for June 24th and it goes away or it gets shortened for whatever reason, we'll contact you and we'll bump you up, okay?
I very much appreciate it. I know XTO does as well. Thank you very much.
Excellent. Thank you. Appreciate it. Anything else on this particular case?
Nothing from me, Mr. Chair.
Okay, excellent. Then, we can move on. Thank you. We can move on to our next case. Our next case
Mr.
is
Chair?
case. Yes. Did I mess
Mr.
up?
Chair, if you allow me, Mr. Tremaine, I would find it helpful potentially if the OCD would look at this case. We're looking at exceptions to wellbore design. If my memory serves me, I read through this a few days ago. I saw where I believe it was XTO mentioned that BLM was good with the proposal, but if the OCD were to take a look at this and opine, that might be helpful to the commission.
Thank you, Mr. Chair, Commissioner Bloom. I can clarify. I didn't mean to be cryptic. The commission, the division has engaged with XTO on this and just reviewed the plan already, has discussed this with XTO in advance, and actually those conversations gave rise to the application to the commission for the exceptions. What I'm working on with our technical staff is whether there's going to be any smaller issues on which we need to present an affirmative case. It was the division's perspective that because of the order of events that I won't belabor now, the timing of when things happened, that it was necessary to come back to the commission. That was one of our requests. For the most part, the technical team is okay with what's been proposed so far. And I'm intentionally understating that to reserve our ability to present any case. So I don't believe that we're going to be coming in and presenting any strong opposition, probably cross-examination and participation. But it is something that's already been reviewed, and I will work with our staff to make sure that a representative of OCD is available to indicate as such and describe their technical review for the commission.
Yes, thank you, Mr. Tremaine. Something along those lines would be helpful, and or if the OCD were provide XTO with some sort of document or anything else they could present to us that shows that the OCD has no issue with the proposals would be helpful. So thank you.
Excellent. Any other questions, Commissioner Mpoma? Did you have any questions for this particular case before we move on?
No, not
Just
from
on
us.
the merit.
Thank you.
Okay, excellent. Okay, if nothing else, thank you, gentlemen. Appreciate it. Mr. Rankin, thank you as well. Okay, so we'll move on to our next case, which is case number 23580. It's an application to amend the Commission's rules to address perfluoroalkyl and polyfluoroalkyl substances and their use in oil and gas extraction under 19.15.2, 19.15.7, 19.15.14, 19.15.16, 19.15.25 of the New Mexico Administrative Code. This is Wild Earth Guardians and New Energy Economy's joint motion for clarification. Are all parties present? I can see you all. I think you're present, but let's make sure everybody's present.
Good morning, Commissioners. This is Tim Davis with Wild Earth Guardians.
Good morning, Commissioners. Marian Lanassi on behalf of New Energy Economy.
Thank
Good
you.
morning, Mr. Chair and Commissioners. This is Jesse Tremaine for the Oil Conservation Division.
Excellent. Thank you. Anybody else?
Good morning,
Maybe.
Mr. Chair, Commissioners. May it please the Commission, Adam Rankin with Holland and Hart, appearing on behalf of the New Mexico Oil and Gas Association. Good morning.
Thank you, Mr. Rankin. Anybody else?
Good morning, everyone. Dina Bennett with Model Sperling on behalf of EOG Resources.
Ms. Bennett, thank you. Anybody else? Okay. Mr. Davis, we'll start with you.
Thank you, Mr. Chair, Commissioners. Our motion asks the Commission to deliberate about an issue that was raised and addressed during the evidentiary hearing last November, but was not discussed during deliberations this March. And that issue is the scope of the PFAS ban that this Commission will adopt. To provide a brief roadmap, I'll first explain the authority the Commission has to engage in deliberations on this issue. I'll next explain that the Commission did not address the scope of the PFAS ban during the prior deliberations and instead adopted OCD's pre-hearing red line rule, which limited a PFAS ban to completions and recompletions. And this is a provision that the OCD proposed prior to agreeing during the hearing that a ban in all downhole operations is more appropriate. Next, I'll explain that the record in this matter supports a ban in all downhole operations. And finally, we'll ask the Commission to engage in deliberations on this specific issue. First, the Commission's rules for rulemaking proceedings provide that the commission can deliberate on the issue raised by this motion. The commission's procedural rules state that the commission can deliberate and act in in open session at any commission meeting, provided that the deliberation and possible action is listed on the meeting agenda. And those are the only restrictions on when the commission can deliberate. It just has to be noticed. The commission's rules don't place any limits on when the commission can deliberate, how many times the commission can deliberate, and it just has to be in an open session like we're in today. Because the commission did not discuss in its prior deliberations whether the PFAS ban would apply to all downhole operations, we're just asking the commission to deliberate on that issue. NMOGA, EOG, and Mr. Maxwell cite to the Pubco case in their response to our motion. And they argue that the commission cannot even hear the motion that we're here about today. And that reliance is misplaced. Pubco simply states that only an applicant for a rehearing can request review in the district court of a decision that denies that rehearing. We're not here today asking for rehearing. We're asking the commission to deliberate on the record that exists, the record that was developed in November, because the commission did not deliberate on the scope of the PFAS ban during the March deliberations. As I previously stated, under the regulations for rulemaking hearings applicable here, this commission can deliberate at, quote, any commission meeting as long as the deliberations are noticed. They also argue that a motion for rehearing is the, quote, exclusive means to seek the relief that we're asking for in this motion today. And that's simply not true. Nothing in the Oil and Gas Act or the regulations supports that moving for rehearing is an exclusive means. And that's why NMOGA, EOG, and Mr. Waxall cite no authority for that position. And I'd just like to reiterate that the scope of the PFAS ban is really important here. If the PFAS ban only extends to completions and recompletions, an operator can use as much PFAS as they want during, for instance, the drilling operation. And that would defeat the purposes of this rule, which is to protect the environment, the public health, and freshwater resources. So next, I'd like to talk about how this issue arose during the hearing and what happened. During the prior deliberations in March, the commission voted to adopt OCD's red line proposal for section 19.15.14.9C. And that proposal from OCD, based on their pre-hearing position, limited the commission's ban on PFAS substances to only completion and recompletion activities. Wild Earth Guardians and New Energy Economies proposed amendments to 19.15.14.9C NMAC addressed two separate issues. One was banning undisclosed chemicals, and that's something that this commission rejected during deliberations. But when that discussion was taking place, the commission did not discuss the other provision in the proposed rule under that section, and that was the scope of the PFAS ban. So both the undisclosed chemicals ban and the ban in all downhole operations were encompassed in 19.15.14.9C of the proposed rule. And so when the commission voted to adopt OCD's pre-hearing provision, it only dealt with the discussion around undisclosed chemicals. You may recall that during the hearing, this question of the scope of the ban in all downhole operations or just limited to completions and recompletions was the subject of significant discussion. And there's evidence in the record to support the ban on all downhole operations that the proposed rule requested. I won't repeat that evidence here, but it is outlined in our final brief, in this motion, and our proposed statement of reasons. But as one example, I would just point to Wild Earth Guardian's Exhibit 37, which is the Gluge et al. Study, which says that since 1956, PFAS has been proposed to be used or used globally in oil and gas extraction methods other than fracking, including chemical-driven gas production, chemical flooding, and the drilling that precedes fracking, and all other oil and gas production techniques. And so at the hearing, OCD witness Brandon Powell agreed in response to questions from Commissioner Ampoma that the OCD supports a ban of PFAS in all downhole operations. Mr. Powell confirmed this position in response to questions from OCD's counsel. Guardians and New Energy Economy discussed the downhole operations issue in their brief and requested a PFAS ban that covers all downhole operations. OCD also agreed in its closing statement that the PFAS ban should extend to all downhole operations. And if there are any questions about where all of that is in the record, I'm happy to provide it. But again, it's in our brief, it's in our motion, and it's in our proposed statement of reasons. I would like to emphasize that we are not seeking to reopen this hearing. We're asking the commission to deliberate and decide on the scope of the PFAS ban based on the evidence presented and admitted during the November hearing. So in closing, I think it's important that this commission consider the scope of a PFAS ban and deliberate specifically on that issue. A regulation that bans PFAS in some but not all downhole operations is not sufficient to protect the environment, human health, or freshwater resources. We ask you to consider it, address the scope of the PFAS ban that you will implement in further deliberations. And as I stated, the commission has the legal authority to engage in further deliberations concerning this issue, and it can make a decision on the evidence that is already in the record. But thank you for your time. Thanks for hearing us this morning. That's all I've got.
Thank you, Mr. Davis. I'm just going to go across the screen and the room. Mr. Tremaine, anything you'd like to add?
So, Mr. Chair and Commissioners, the division did not take a position on the motion. And so I do think it would probably be prudent to hear from the parties in opposition. Next, there's the motion presented to the commission now is one that I view as having procedural ambiguity. I would agree that it appears that the commission can notice and deliberate on what they want. When they want, I don't see that as limited in time frame. It's subject to notice requirements. However, my only comment would be that I encourage the commission to, if it decides to reopen deliberations, that decision be based on a narrowly tailored and specific reason. If you feel that there is a necessary correction because there is something that was necessary for deliberations that was not deliberated upon, perhaps that is a basis for further deliberation. I am cautious that such motions, not necessarily this motion, but such motions in other rulemakings could extend procedure unnecessarily. Because of their procedural ambiguity, we're towing a line between the closing of evidence and reopening a hearing. And I do have concerns that all parties in other contested matters could utilize this as a means to extend deliberations and reopen evidence indirectly. I'm not suggesting that that's what these petitioners are doing, because there was something specific that I do not see addressed in the record. I think that is true. So my only comments again are, I'm not sure how this fits in with the procedural rules. And if the commission decides that further deliberation is necessary, I think it needs to be based on a very narrow and specific finding that something was missing and inadequate in the deliberation process. Thank you.
Thank you, Mr. Tremaine. Mr. Rankin.
Good morning. May it please the commission. Thank you very much, Mr. Chair, commissioners. I want to echo what Mr. Tremaine was saying, but I'm going to put a finer point on it. I'm going to point to specific requirements and limitations imposed on the commission during its deliberations and rulemaking after the record has been closed. Wildlife Guardians and New Energy Economy's efforts here to influence the commission's deliberations after the record has been closed, but before a final order and statement of reasons issues is improper. It's also procedurally improper and must not be countenanced by the commission because it's outside the scope of what is authorized under the regulations and the procedural orders that govern the rulemaking. The commission has conducted a final vote on the proposed rulemaking, and the record has been closed for all purposes other than for the commission to deliberate on the final form of the written rule that it has orally approved and its statement of reasons. A petitioner's motion for clarification is the equivalent of a last-ditch effort here to sway the commission in its deliberations, during its deliberations, by interjecting additional arguments after the record has been closed and the parties' final statements, arguments, and positions have been submitted and considered by the commission. The commission's petition here, or motion, is no different than an effort to interject additional comments or new arguments during the commission's ongoing deliberations, which is exactly what happened during the commission's last session on this matter, when petitioners' counsel improperly commented during the course of the commission's deliberations. Petitioner's motion is a continuation of that same effort to influence the commission's deliberations, and it shouldn't be considered. To consider it, to respond to it, would invite error. Under the commission's rulemaking regulations, the record can remain open at the close of a hearing for written submittals and proposed statement of reasons. It's expressed under the commission's regulations. That's 1915-3-12-A-2G, and I'm happy to put that on the screen so we can all look at it. The regulation specifies that the record shall remain open after a rulemaking hearing only for the purposes and timeframe specified. That's exactly what happened here. After the close of the rulemaking, the hearing officer issued an order setting a deadline for post-hearing submittals on or about February 14th, 2025. That order specified that any party may include a closing legal argument and/or proposed findings and conclusions by February 19th, 2025. That was the limit for which the record remained opened and the deadline in which the parties had to provide additional comments or arguments. The parties to the rulemaking, including petitioners, submitted their post-hearing submittals to that order on February 19th. After that date, and for all other purposes, the record in this rulemaking was closed to all other submissions by the parties, including arguments, motions, positions, findings, conclusions, any opportunity to alter or affect the outcome of the rulemaking after that date was effectively terminated. Okay. So efforts here to comment on, ask for additional deliberations during the commission's deliberations is improper. The record has been closed and nothing further should be contemplated. Both efforts to influence the commission's deliberations, both during the course of deliberations at the last session and through this motion, are improper and should not be considered. Now, in addition to being procedurally improper, the petition's motion also is premature. It's nothing more than a motion for rehearing in disguise, but prematurely. A motion for hearing is what the parties of record who are adversely affected by a commission order may file after the commission issues an order adopting a rule. That's laid out in the commission's rules at 1915-3-15A. Parties dissatisfied with a rule the commission votes to adopt or believe that there is an error or a mistake or what have you, are not free to raise their hands to file motions to clarify and attempt to influence the course of deliberations after the commission has already voted, but before issuing a final written order and statement of reasons. That's outside of the scope of the rulemaking, the rules. They must wait for the order and the statement of reasons to issue, and they can, within the 20-day rehearing period, then file a motion for rehearing and make their arguments at that time. To do so now, at this time, during the proceedings and final deliberations, is improper and should be rejected. Not only is petitioner's motion procedurally improper and premature, but their effort to expand the scope of the rulemaking is not supported by the record. Petitioners contend in their motion that the difference between banning PFAS and fracking is, quote, let me rephrase that. The petitioners contend in their motion that, quote, the difference between banning PFAS and fracking versus all downhole operations is significant. We agree. The rulemaking record does not support significantly broadening the scope of the rule to all downhole operations when the evidence and testimony presented to the Commission was related to completions, recompletions, hydraulic fracturing operations, shooting, and chemical treatment of wells. That was the scope of the rulemaking. There are many other types of potential downhole operations for which no evidence was presented during the course of the hearing. Whatever other operations petitioners may want to capture in this rulemaking were just not contemplated or addressed in the evidence in the record. Petitioners presented no experts on downhole operations to explore the type of operations that they now contend are contemplated to be within the scope, other than the operations I just enumerated. For example, logging, coring, running wireline tools, none of those operations were addressed in the hearing and before the Commission, and therefore the Commission has no information on which to base a decision about whether those should be not included within the scope of the rule. The only place downhole operations is used in petitioner's final proposed rule is as part of the definition for chemical disclosure list and as part of the proposed provision addressing certifications for APDs. Otherwise, the phrase downhole operation is not used anywhere else in the context of a petitioner's final rule. The commissioners have already agreed to adopt OCC's approach, which strikes petitioner's proposed definition of chemical disclosure list. So the term downhole operations is not needed for that purpose. And the other place it appears, as I mentioned, is in the certification for APDs. Here, there's just no evidence, testimony, or record on what the potential implications would be if the scope were expanded as petitioners requested. They cited two witnesses in their motion and their reply brief in support of their argument that the record supports expanding the scope, but the testimony cited does nothing to establish a technical rationale or basis in the record, especially compared to the detailed and technical testimony the Commission actually received on the types of operations that are clearly within the scope of the rule. If they want to come back and amend the rule later to include additional activities based on some evidentiary record, they can do so, but only after establishing an evidentiary record that justifies it. Mr. Chair and Commissioners, our view is that the record has been closed and that this effort to influence, modify the course of deliberations is improper and shouldn't be countenanced. The motion should be denied. And if the petitioners want to come back and seek a rehearing or point out an issue that they believe is error or should be corrected, they can do so at the proper time. Thank you.
Thank you, Mr. Rankin. Ms. Bennett.
Thank you very much. EOG Resources joined in NMOGA's motion or NMOGA's response to the motion, and EOG agrees with NMOGA's arguments and concerns, which Mr. Rankin just expressed, and requests that the Commission deny the motion. Thank you.
Excellent, thank you. Mr. Davis, I'll give you the opportunity to be able to state your points after hearing what was stated.
Thank you, Mr. Chair. I'll be very brief. We're here to just point out an oversight that happened during deliberations. The only relief we're asking for here is further deliberations on the issue that wasn't discussed during deliberations. We're not providing any additional arguments. We're requesting that the Commission make a decision based on the record that was presented in November. And we filed this to avoid further procedures like filing for a rehearing. And we've provided the Commission with the legal basis to show that it can engage in deliberations at any meeting, as long as it's noticed and it's an open meeting. And I'll just point out that NMOGA seems to want to make this about each individual downhole operation that could be possible. But really what we're here about is protecting the environment, the public health, and freshwater resources from PFAS. And that is something that we talked about at length during the hearing. There's ample evidence to show its environmental and public health harms. And if it's harmful to send it downhole in one operation, it's harmful to any new pathway into the environment for PFAS is harmful. So you have ample basis based on that. But if you look into the record, there is other evidence. And again, I'm not going to repeat it here, but it is outlined in our briefing. You have ample grounds on which to ban PFAS in all downhole operations. Thank you.
Thank you, Mr. Davis. I do know Miss Orth is on the platform as well. And Mr. Chandler, I kind of, before we open it up to the commissioners with questions that they may have, any opinions that you all may have?
So this is Mr. Chandler. So Mr. Chair, it comes down to 3 words, and that is in the application section, 19.15.14.9C. And it comes down to the phrase in downhole operations, which would be after the phrase PFAS chemicals. The evidentiary record is closed. The question is whether the commission wants to reopen their deliberations. 2 different things. The question for the commission, do you want to reopen your deliberations for the narrowly tailored discussion of whether those 3 words should be inserted into the rule? As you may recall at the meeting, it was a tie. So the petitioners wanted those 3 words. The Oil and Gas Association did not. We looked to the division to break the tie. The division in its red line did not include those 3 words. And so the tie was broken not to include those 3 words. Subsequent to that, the petitioners have said basically that there was ample room to interpret the division's position differently. And as they've stated in their brief, they believe that even though the division's red line didn't include those 3 words, their closing brief said that they supported those 3 words. And again, they repeat that today. So kind of the $64,000 question is, did the division really support those 3 words? And for 2 months now, I've been waiting for the division to tell this commission yes or no, whether the statements it made in its closing brief should be read to mean that they didn't support those 3 words, even though it wasn't in their red line, or for them to stand up today and say, that is a misrepresentation by the petitioners. I have not heard from the division that that is a misrepresentation. So perhaps do you want to hear more from the parties about that? But that's what I was waiting to hear. And if it was a misrepresentation by the petitioners, then I would advise you not to reopen your deliberations. If it is a correct representation by the petitioners, I do think the agenda is worded enough that it's a logical outgrowth that you can grant the petitioner's motion. You can then make a motion to reopen deliberations for the narrow purpose of those 3 words, then close your deliberations, and then proceed to your adoption of the final order with the statements of reasons.
Thank you, Mr. Chandler. I believe you're done, correct?
Yes.
Okay, I appreciate it. Commissioner Bloom, I do see that your hand is up. Is it directly to what Mr. Chandler said, or is it questions that you, and there's a reason why I'm asking. I did also pose the question to Miss Orth, and I wanted to make sure that we got hers in before we got your question, but if your question is to what Mr. Chandler said, I'm happy to entertain it now.
Thank you, Mr. Chair. Yes, it's a question of Mr. Chandler, and
Okay.
If you'll permit me, Mr. Chandler, I would probably agree that a lot of us would like to hear from OCD on this, but by doing so, we'd be reopening the evidentiary record and introducing something new here. I guess that's my first question, and I might have a follow-up.
So I must admit, Mr. Chandler, that's my question as well. If we do get information from the OCD stating that the information was a misrepresentation, does that open us up to, is that a reopening, or is that something that you see that will allow us to be able to say yay or nay on reopening this? I'm trying to figure out procedurally how that works.
Yeah, so Mr. Chair, I'm not asking to reopen the evidentiary hearing. I think there's enough in the evidentiary hearing that, like on page 37 of the petitioner's closing brief about Mr. Horowitz's testimony, Mr. Powell's testimony. I think what I was looking for to see if OCD thought when my judgment call was the closing brief was not clear enough to break the tie, whether they were going to weigh in on that. But I can understand your point if you feel like that would open the door to the evidentiary hearing. I think both options are on the table.
So, Commissioner Bloom, I just wanted to make sure, did that answer your question, at least for a little bit?
That does, and I mean, where I'm going is, we've all spent a considerable amount of time on this. I think we would like an order that stands up to any subsequent review or challenges. So I wanted to be mindful about doing something that looks like a de facto or real reopening of the hearing. And I am grappling with how we deal with this, and maybe just a follow-up from Mr. Channel would be, would the commission be okay? Are we still going to be on solid ground if we reopen to deliberate on this point that was raised in a motion for clarification? Or is it, or would you counsel that we look at rehearing?
Well, I think before Mr. Chandler can answer that, I think the question is going to be, do we want to reopen this, yay or nay? I think if we decide to reopen this, then I think your question is going to be valid. The question I think before the commission right at the moment is, do we want to reopen this and deliberate? Do we feel like we need to deliberate more on this, or do we stand on our decision? But before we proceed with that particular question, Miss Orth, was there anything that you wanted to add as the hearing officer?
Thank you, Mr. Chair. Is my volume okay?
Yes, it is.
All right. So I am on the platform, not because the motion was to me, the motion is to the commission. And unless you reopen the evidentiary record, I don't have a role. I guess I would offer two observations, though. One is that I agree with everything that Mr. Chandler said as he was describing what the path to this meeting is or was. At the same time, the motion did not request a reopening of the evidentiary record, and I don't think it would be necessary. We have historically drawn a distinction between the evidence that is introduced and admitted into a record and the final position that is taken by parties, usually expressed by their counsel in closing argument, right? That's not necessarily evidence, that's their final position, which is not, again, historically considered evidence. That we say, we don't take evidence from lawyers, for example. The other thing is I spent the last day and a half at the Roundhouse with the Water Quality Control Commission, in which they did exactly what Mr. Davis is asking this commission to do. On further reflection, about a month after they deliberated on the produced water reuse rule, they went back and revisited it before they made a final decision and made some fairly significant different decisions there. So again, I agree with Mr. Chandler, and I would add only that I think there's a difference between reopening the evidentiary record and understanding what a party's final legal position is. That's all.
Thank you, Ms. Orth. So, commissioners, I guess we are at that point where we need to decide how we want to proceed. Commissioner Mpoma, I'll start with you. Any questions that you may have also legally to Mr. Chandler?
And Mr. Chair, I saw Mr. Tremaine raise his hand. I don't know if you caught that.
Oh, did Mr. Tremaine raise his hand? I apologize. I did not see that. Thank you for catching that, Commissioner Bloom. Mr. Tremaine.
Thank you. So to clarify a couple things, the red line version, and I'll chalk this up to, I'll call this a learning experience. We did not submit a final red line and instead relied on a record from the hearing and the parties' red lines. So the red line that's being referred to is the one that the division submitted prior to the hearing. I have not commented on OCD's position on this and referenced the record out of paranoia that I was opening the evidentiary record. So OCD's final position was that, and we do believe that it is reflected and supported in the record, that downhole operations was appropriate. And I think that all of the parties found that to be acceptable at the hearing. So that when push comes to shove, yes, that was OCD's position, that was acceptable.
Okay. So that definitely opens up and changes some things here. Mr. Rankin.
Thank you. I just want to make clear that it was not acceptable to NMOGA. This issue came up, and it's clear in the record, I think the second to last day of the hearing, and Mr. Tremaine can clarify this as well, but up until that point, we had understood that the rule was limited to the operations I outlined in my argument, that and it was only at the second to last day of the hearing when Mr. Davis approached the parties about this, that we understood that petitioners had intended to have the scope extend beyond those operations to include every conceivable downhole operation. And Mr. Tremaine, I think, can speak to that as well, because throughout parties' discussions leading up to the rulemaking, that was never our understanding. And so at the time of this announcement or effort to confer during the rulemaking, we did not agree.
Okay, Mr. Davis, I see you on the.
I just only want to make one quick point, which is that our red line proposed rule has always included a ban on PFAS in all downhole operations. I stated it in my opening statement. We provided testimony on this issue during the hearing, so our position on this issue has never changed.
Okay, thank you. Ms. Bennett, did you have anything you wanted to add?
Thank you. I concur in what Mr. Rankin stated, including the untimeliness, the lack of information or notice about the broad implications of the change that has been discussed today.
Okay. Thank you, Ms. Bennett. So, Mr. Chandler, with what the OCD just stated, what advice do you have for this commission now?
So, Mr. Chair, I guess I take the philosophy, it is what it is. So I think the commission has within its authority to grant the motion and reopen the deliberations for the narrowly tailored three-word, change. I think the commission also, it is what it is. It's possible this rule could be appealed. It's possible this creates an additional appealable issue. That is the risk the petitioner has taken by coming back here. I think you should do what you think is the right thing to do, and we'll handle it from there.
Okay. So let me then open it up to questions from the commissioners. Commissioner Dr. Mpoma, please.
Thank you, Mr. Chair. So I do know that during the discussions that we had, multiple times, the definition of the downhole operations came up, and we strike it down. So, and the reason was that, OCD said there's a common industry term. Defining it may cause unintended limitations to the scope and they potentially affect other rules. Now, if we are going to use the term downhole, or let's say even we are going to open it up to discuss the term downhole operations, we decided not to include that, as part of the definitions. So to me, I don't know how that is going to more or less impact the entire discussions that we had as part of the hearing. So, Mr. Chandler, my question to you is, we strike down the definition of downhole operations. We decided not to use it at all in the rulemaking. I believe that is why whenever we were going through the deliberation, wherever we see downhole operations, we said, no, we said we are not going to use it. So we took it out. So how does that change the dynamics here?
So, Mr. Chair, that does seem to be an important factor, that if you feel like the commission did deliberate this type of term and did break the tie that way, then I would advise you to deny the motion.
Okay. Dr. Mpoma, did you have more questions?
No, I do not.
Okay. Commissioner Bloom.
No, no, not a question right now. If we're going to discuss deliberating or not, I would. I'm ready to do that.
Okay. So I guess then, commissioners, the question is: do we want to take this on to take the petitioner's request, or do we leave it as is and say the decision was made? And we move on. So, Commissioner Bloom, did you have questions on that? Statements?
Yes, Mr. Chair. Again, my goal at this point is to create a defensible order, a strong order. But this does come in. It does raise some issues. I believe we should deliberate whether this rule should apply to all downhole operations. Without getting into a deliberation itself, the fact that we struck that definition of downhole was based on the idea that this is a commonly used term and didn't need to be defined or limited. So I don't believe that means we can't include that, but I don't want to get into, I guess, a deliberation here before we actually decide if we're going to do that or not. So I think, as Mr. Chandler indicated, perhaps not ideal. We can deal with the consequences of this later, but I do believe that this merits us deliberating, Mr. Chair, Dr. Mpoma.
Okay. So your vote is to have the deliberation. Is that what I'm understanding?
Based on what I've heard so far, I don't know what else you might add, Mr. Chair, or where Dr. Mpoma would ultimately land. So.
Okay, but your vote is to deliberate. Is that what I'm hearing?
Well, I don't know. I would want to hear what other issues people raise here,
Okay.
and then we could vote.
Okay. Dr. Mpoma.
Yeah, so I do have a question for my co-commissioners, and it's the same question that I asked council. So we strike down the downhole operations in our deliberation, and if you go back and check all the transcript, you will see that anywhere we see downhole operations, we strike it down. So if we are to reconsider this, don't you believe that it's going to impact most of the decisions that we made during the deliberation?
Commissioner Bloom, I'll start with you.
Thank you, Mr. Chair. Dr. Mpoma, Commissioner Mpoma, that is a good question, and I would look forward to having that conversation and deliberating on that and how it might work itself through the rule. So again, I'll state my support for having these deliberations.
Thank you, Commissioner Bloom. Dr. Commissioner Mpoma, I do believe that it does cause definite implications. There are definite implications, as you're indicating and you're intoning in your question. I think the deliberation would definitely open it up, and it would kind of change things to the way that we have already decided as a commission. And so my stance is that we don't change anything. The decision was made with the way that it was made. The three commissioners did come up to that conclusion, and we worked on it the way we did. So that's my stand. How about yourself, Commissioner?
Thank you for that. And I do have another question for my co-commissioners. So if you look at the OCC PFAS rulemaking order that our council put together, so on 19.15.14.9 on item C, so an applicant for a permit to drill, deepen, or plug back shall certify that they will not introduce any additives that contains PFAS chemicals in the completion or recompletions of the well. So to me, I'm asking my co-commissioners, don't you believe this is comprehensive enough? Because if you're going to drill a well, or let's say deepen the well or plug back, you need to show that you are not using PFAS. So I believe that during our deliberation, we captured this, all the concerns, in this item. So I believe it was not deliberate on the part of the commission to, let's say, to ignore the downhole operations, and we're very specific in our ruling. So I will still stand by. We definitely probably do not need to open this up.
Okay. With the statement that was made from Commissioner Mpoma, Commissioner Bloom?
Yes, Mr. Chair. Dr. Mpoma, you raise a good question there, and I think we, as a commission, didn't answer all these questions and issues, and that by reopening deliberations, we can have that conversation and take some time from between now and when we do this, perhaps in June or July, and look at those issues and see how this would permeate itself through the rule. I think this is a good time to do this. It might save us from a rehearing or a new petition from the petitioners, where we would spend another week or portion of weeks hearing all new evidence on this. I think that there are some weighty matters to discuss here.
Okay. Thank you, Commissioner Bloom. I have to just take my stance again. I think the decision was made. I think it was whole, and we did look at it completely, and that we were looking at everything. And so I have to agree with Commissioner Mpoma on this one as well. So any other questions, Commissioner Mpoma?
Commissioner Bloom, so let's say if we agree to go to deliberation on this, you know, in that case, are we looking at the downhole operations, or what are we going to look at, especially when we strike it down?
Yes, Dr. Mpoma, I think we would be looking at sort of the gamut of downhole activities that occur that the proponents mentioned in their motion for clarification. I don't know if I have that handy, but I think we're talking about aspects of well treatment, maintenance, drilling, and enhanced oil recovery. You know, and I think we all remember from the hearing that, you know, a lot of the threat from these chemicals isn't just what happens downhole. In fact, that may be where they're safest in some sense. It's having these chemicals brought into New Mexico, right? These chemicals that are toxic at the, you know, teaspoon per Olympic swimming pool or 100 Olympic swimming pool level, right? That these chemicals come into the state, they're mixed, they're transported, they're, you know, we've seen the you know, spill data. I think some of that was presented, surface spills, you know, what this kind of means in its entirety for us. So, you know, I think there's a little more here to discuss, and I don't know if you would agree with me on that, Dr. Mpoma.
You know, on that one, it sounds to me you are extending the scope of the discussion, because the way I see it is that once we open it up for downhole operations, then we're going to be forced to define what the downhole operations is. And that more or less, you know, negates most of the discussions that we had, you know, as part of the deliberations. You know, in as much as I do appreciate your position on this, I believe, you know, strongly that we considered all of this in our deliberations, and it was not intentional. You know, at least for on my part, it was not intentional to probably forget about what was discussed during the hearing. So I will still vote with the chair on this, not to reopen this.
So let's just make an official vote then here and now. So the question is, are we going to hear this as the petitioners have requested? All in favor, say aye.
I would vote aye to reopen and deliberate on this point.
Okay, all against?
I will vote against.
I am against as well. So we won't be opening this. Mr. Chandler, at this point, then how do we proceed?
Okay, so Mr. Chair, so for the record, the joint motion for clarification has been denied. I would advise the commission to go to the next bullet point, the adoption of the final order. I provided a statement of reasons. I've only received comments from Commissioner Bloom, so I could walk through his proposed changes if that's what you want to do as the next step.
Commissioners?
That, Mr. Chair, that would be fine by me. I think I had two major questions. I don't know if we refer to petitioner in the plural or petitioners singular or plural with a plural s, or for the possessive. But and then I think I wanted to add one more bullet down towards the bottom of the order, just strengthening a little bit, I think, on some of the public health aspects. But I'm glad to speak to any of that, and maybe another couple typos I have, but I believe that's it.
Okay, Commissioner Mpoma?
Yeah, Council. So I had one question that I discussed with you. So if you look at the rule that was passed by the legislature, there was a definition of unintentional use of PFAS. So we discussed that, and then I wanted to know how that impacts what we have here.
So, Mr. Chair, I did look at the two laws that were passed. And my advice to you is they do not impact this rule.
Thank you.
So, Commissioner Mpoma, did you want to review the notes that Commissioner Bloom put? Yes or no?
Yeah, so this is the first time we've seen it. So if we can walk through that briefly, that would be wonderful.
Yes,
I'm wondering
Mr.
if
Chair.
we could do this through screen share, Mr. Chair.
I would actually ask Mr. Chandler, do you have the ability to screen share?
I do not have the ability to screen share. I don't know if Sheila does.
I believe I do, Mr. Chair, and I could pull up my few handful of edits and a couple questions and one added bullet point.
Great, thank you, Commissioner Bloom.
All right, let me see here. Try this. Okay, I think I'm getting there. All right. All right, here we go. Let me go up to the top. I trust you can all see my screen.
We can on the platform. Can Pecos Hall see it?
Yeah, can you make it a little bit bigger?
Let me see. Yes, let me try and do that for you. Is that any better?
Yeah, let's scroll down and see. Yes.
Oh, okay, good. All right. It's pretty blown out now, but let me try and navigate here. Oh, okay. 2 is just, I think, almost like a typographic fix here. I would just add studies of, so that this reads that the division's witness, Dr. Eric Martin, stated that studies of PFAS chemicals have shown that there are toxicological effects on humans, versus saying that the division's witness, Dr. Eric Martin, stated that PFAS chemicals have shown there are toxicological effects.
So, Mr. Chair, that's a typo. I can correct that.
Okay.
And then I think another one that I flagged, Mr. Chandler, was just petitioners. It's they're joint petitioners. I don't know if that should be plural, possessive, or whatnot. I don't know how you want to handle that. Might not matter.
So, Mr. Chair, I just stuck with petition for possessive, not a plural.
I think that's fine. I'll drop that. Groundwater is often one word.
I made that correction.
Okay, thank you. I don't think I have too much more. Just getting down to page 15. Okay. So this is under the section of related to frac focused disclosures and why we want to do this. The commissions are, the reasons why are, number one, the petitioner's proposed change. Chemical disclosure list was not adopted. Number two, operators already disclosed constituents in their fracking and completion fluids. Number three, we have, it's important to provide information to the public. And I would want to add this number 4 here. That public access to chemical disclosure increases trust in regulators. And that's from the petitioner's post-hearing closing brief, page 41, citing to Brown, OCC transcript 11/12/24, page 257, lines 21 through 24, and page 258, lines 1 through 5.
Mr. Chandler, did you have any statements on that?
Mr. Chair, I double checked the citation is accurate and I can add this.
Okay, Commissioner Mpoma, are you okay with that?
Yeah, Mr. Chair, I do not have any concerns with that. Thank you.
Okay, neither do I. So, Mr. Chandler, if you'll make that change.
I believe that may be it. Let me just go down a little further. I'm down at the end here already. I believe that is all I had.
Okay, Mr. Chandler, is those the same edits that you had as well, but plus a few other typographical?
Yes, Mr. Chair, I can include all these typographical corrections and get you a copy for you to sign later today.
Okay, so at this point, do we just need to all three agree to adopting this? Is that our next procedure?
Council, so Commissioner Bloom, if you can bring it up one more time, I want us to look at page 11.
I may have closed that window. 1 second.
Okay.
Let me go back and open it. We go down to page 11 and then I'll zoom in, Commissioner.
Yeah, page 11.
Okay, page 11.
Yes.
Am I in the right spot, Dr. Mpoma?
No, it's not moving.
Okay, let me scroll down. Tell me when to stop.
Yeah, you're still on page 5.
It's not moving on our end, Commissioner Bloom. You may want to unshare and maybe reshare.
Let me try that. Yeah. Try that again. That's the wrong document. 1 second. Okay.
Yeah, if you can go down a little bit. So, you're going too far. So just the last point, number 4.
Yeah.
Yeah. So, Council, if you look at number 3, you're saying the petitioner's proposed change to include undisclosed chemicals was not adopted because this term was not adopted in the definition session. So the number 4, I will say that we have to follow the same suit because not necessarily is it because of OCD's less whether they did red line or not, but the commission did not actually adopt the definition of the downhole operations.
So, Mr. Chair, number 4 is now a stale point. And I will then rewrite 4 to model after 3, okay, almost verbatim. Will you be comfortable with that? And then I can do that and you can still have the chair sign it?
Yes.
Okay. Any other questions, Commissioner Mpoma?
No, Mr. Chair.
Okay. Commissioner Bloom, anything on these edits that we're discussing now?
No, Mr. Chair.
Okay. So, Mr. Chandler, do we now move to accept these edits?
Please.
Okay. So can we get a motion to accept the edits as we have just now discussed?
Yes, Mr. Chair, I move to accept the final order in this case with the edits that we have just discussed.
Okay, excellent. Can we get a second?
I second.
Okay, so these orders, the way that it has been presented and we just discussed with the changes, have been approved. And Mr. Chandler, if you'll make the changes for signature and send it. Oh, we need to do an all yay or a nay, right?
Sure.
I am slowly learning. I apologize, Mr. Chandler. I am slow on the uptake, but I do catch myself, so my apologies. So all in favor for all for these changes as it was motioned?
Aye.
Aye.
Aye. Okay, there are no nays. It was unanimous. So now they have been accepted. So Mr. Chandler, if you'll make the changes and submit them for signature, we would appreciate it. Okay. Anything else on this particular topic?
Mr. Chair,
Yes, Mr.
I'd like to thank the commission for considering our motion and our proposed rule. Thank you.
And thank you for bringing it in front of us, Mr. Davis. We appreciate it. Okay, this case is now done. We'll move on to our next point. Mr. Chandler, was there any pending litigation?
No, Mr. Chair.
Okay, excellent. Was there any other business that we needed to discuss? Okay, excellent. There's no other business. Our next meeting is going to be next week, May the 19th, 2025. And if there's nothing else, this meeting is adjourned. Thank you, everybody, for your assistance. We will see you next week. Have a good weekend.
Thank you.